So I get this situation a lot with clients is they want to collaborate with somebody, and that's what this question is about. Is what are the benefits and challenges of collaborations like joint ventures, partnerships, and how do you manage the intellectual property rights? And it's rife with danger, right? You know, the power of collaboration is absolutely a real thing. The problem is owning property, intellectual property, is all about exclusive ownership, right? It's the difference between, you know, maybe having the ability to use the park and owning a house where you can lock the doors, right? So you'll often get in these situations where you want to team up with somebody for whatever reason, in whatever form that might be. But it does create issues. And kind of first and foremost is what do you do about patents, right? You're going to have perhaps your engineering team collaborating with their engineering team. As this cross-pollination happens, who owns the ideas that come out of it, right? And you might say, well, we'll jointly own them because we're collaborators, right? Well, there are some issues with that. And I can best demonstrate it by kind of posing this problem by way of an analogy. Is in the office I worked in, they had a conference room with 2 doors. And you have 2 people that own the patent, so, you know, we'll say that the conference room is the patent. So I might go in front of one door because I own it, and my joint venture partner also owns it. They might go in front of the other door, and somebody wants to come in, and I say, oh, you know, this patent's very expensive, this technology is very great, I want $100,000. My collaborator is going to hear that and going to say, hey, psst, come over here, I'll let you in for $90,000. And you end up with very quickly a race to the bottom. So generally, when you get involved in these situations, is you want to have somebody in control of the patent, right? So you might have an owner for patents in this technology area and an owner in patents in this other technology area. And maybe there's licensing that goes back and forth, but there is just one owner. And that one owner is probably going to pay for the costs of procuring the patent, but also has all the rights to enforce the patent, and perhaps even has obligations to. Your partner might have the ability to require you to litigate in certain circumstances. But you want to have exclusive ownership, right? It's the difference between owning a house and the park across the street, right? Is, you know, you have very little control over the park across the street because everybody in town owns it, or living with roommates or whatever. When you're dealing with a different company, it causes issues. It also causes some issues, some legal issues with filing patents. When you file a patent, there are circumstances by which, you know, say you file a patent today, and then you file a patent in 3 months. Well, you own both of the patents, so that the earlier patent can't be cited against your later patent in certain circumstances, because they were commonly owned at the time of invention. And you can do priority claims and stuff like that. Well, when you're collaborating with somebody, you might find that, you know, you file the patent here today, and then 3 months later your collaborator files a patent. And you could very well have that earlier patent cited against their later case. And they aren't commonly owned. So sometimes you'll see companies will actually set up an entity that owns the IP for the joint venture, right? Or something like that, so that you have common ownership at the time. But you really have to divide up or figure out the ownership rights. By default, if there's no agreement and you're collaborating with somebody, the party that has the inventors on the patents, so say there's 3 inventors, they all work for this company is going to own the patent. Every inventor starts out with an equal undivided interest in the patent. So if it's 3 inventors, they all work for this company, very clear. What if two of the inventors work for this company and one of the inventors work for the other one? All of a sudden you end up with the joint ownership situation. So it's nice to have an agreement to say, look, in this circumstance, well, the technology is more related to this company, so we're going to send it over here. Or the technology is more related to this company, and we'll send it over there. So you still end up with exclusive ownership, and you've kind of predetermined where it's going to go, right? And you want to do that early on in these collaborations. You know, and that's kind of all the problems associated with this collaboration thing, is because of the patents are an exclusive right. An exclusive right is only valuable when one person owns it. And this issue with joint inventorship that muddies the waters, you know, you really want to think long and hard about it because the power of collaboration is real, but every company wants to own their own intellectual property. So try and figure out a way to divide it up front. And then the other thing that I'll add, kind of rather cynically, is I find my clients always want to collaborate with people. And I don't know what the success rate out the other end is, but it's low. At least maybe my clients are particularly unlucky. But there just ends up being issues, right? You know, maybe the two companies that are collaborating or have big cultural differences because they're from different countries or different priorities from their executives or something like that. Is think about how things break up, right? Maybe one person can buy out the other person, or you can separate it out because you have these two different areas, right? As this person gets this business, that person gets that business. This person gets the software, this person gets the hardware, something like that. Is kind of have that, what I would call a prenup thought process as you get into it, and how it breaks down and how you get out of it. And then it just makes it a lot easier to say, look, this is how it works. You grab the software, I'll take the hardware, no hard feelings. We'll go on our merry way. Maybe there's a cross-license associated with this for a period of time. Maybe there's a buyout. Nail down the exit up front. Because, you know, maybe it's just because I get brought in when the things blow up, so I only see the bad parts of the world. A divorce lawyer probably is pretty cynical about relationships, so maybe that's the perspective that I'm seeing, is that I've been brought in when there are particular problems in a situation. So anyway, that's the things that come to the top of my head as you're thinking about it. You certainly want to have your legal counsel look at it, undoubtedly. So at any rate, if you have any follow-up questions, leave them in the comments below. Don't forget to like and subscribe if you got something valuable out of this video. Thanks.